Welcome back to Legal Threads, where we take real cases and unravel how the law works in practice. Today's story is Pennsy Supply vs. American Ash Recycling, a Pennsylvania case from 2006 that turns on one of the most fundamental doctrines in contract law, consideration. Here's what happened. A school district hired a contractor to build a high school. The contractor subcontracted the paving work to Pennsy Supply. The project specifications allowed the use of an alternative material called Aggrite, made from recycled ash. The supplier, American Ash, advertised that Aggrite was available free of charge to anyone who wanted it. Pennsy decided to use it, picked up about 11,000 tons, and laid it down as the base for the parking lot and driveways. But things went south. The pavement cracked within months. Pennsy had to rip up the defective Aggrite, dispose of it as hazardous waste, and repave the lot at a cost of almost $400,000. When Pennsy asked American Ash to handle disposal, American Ash refused. So Pennsy sued, claiming breach of contract, breach of warranty, and promissory estoppel. The trial court dismissed the case, saying there was no contract because there was no consideration. The judge reasoned that Aggrite was given away as a conditional gift, free material with no strings attached. In other words, Pennsy didn't give anything in return for the promise, so no contract. But the Pennsylvania Superior Court reversed. The key was how consideration is defined, a benefit to the promisor or a detriment to the promisee that is bargained for. The appellate court looked at Pensy's allegations and saw something different. American Ash wasn't being generous, it was trying to offload disposal costs for a material classified as hazardous waste. By giving Aggrite away, American Ash avoided thousands of dollars in costs. Pensy's detriment, taking possession of the waste, was the quid pro quo for American Ash's promise to supply it. That, the court said, is consideration. The judgment was that Pensy's complaint should not have been dismissed. The case was sent back for further proceedings, with breach of contract, warranty, and estoppel claims all back on the table. The thread here is simple but powerful: labeling something free doesn't make it a gift. If the so-called gift confers a real benefit on the giver, and the recipient's detriment induces that benefit, that's a bargain for exchange, and that means contract law applies. That's all for today's episode of Legal Threads. If you enjoy hearing how everyday business disputes shape big legal doctrines, don't forget to like and subscribe for more.